2025, Republic versus Michael Abala Wanga. The orders of the ruling will also apply in E064 of 2025. Republic versus Michael Abala Wanga. It's a brief ruling on 17th November 2025, Honorable Steve Ogola allowed the suspect's notice of motion dated 17th November 2025 with miscellaneous application number E1640 of 2025. Among the orders she issued was the requirement for the suspect to appear before the Ethics and Anti-Corruption Commission on 18th November 2025 to have his statement recorded. On 25th November 2025, parties appeared before me following lengthy submissions. This court restated my sister's orders by directing that the suspect to present himself to the EACC officers to record his statement and for processing as directed. The matter was then fixed for mention on 2nd December 2025 for further directions. When parties appeared before me on that day, that is on 2nd December 2025, the defense counsel confirmed from the bar that the suspect and his counsel indeed presented themselves at the EACC offices by the investigation officer and blatantly refused to record his statement as ordered by the court. He then went ahead to seek orders that the plea in this matter be deferred until such a time that the EACC will have complied with the orders of the court. He further prayed that the terms of the suspect's release of personal bond 500,000 be extended pending plea taking. The defense counsel also disclosed that they have written a letter to the DPP in which they have listed 10 points that they wanted the DPP to address before the suspect hearing can take plea. In his response, Mr. Bore, the prosecution counsel, informed the court, again from the bar, that they have complied with the orders of this court, in that they have already amended the charge sheets as proposed by the defense, and that the suspect hearing was cautioned and processed. He further submitted that on 25th November 2025, there was new information that came up after I delivered my ruling. The new information was that the suspect's statement had already been recorded. He submitted that since the orders did not specify whether or not he was simply cautioned the process and cautioned and processed him by taking his fingerprints. He pointed out that the new information had not been brought to his attention at the time he was responding to the defense counsel's submissions of 25th November 2025. I've really considered the submissions by both sides. Right from the outset, I must emphasize that this court neither can nor should instruct an investigative agency on the manner in which to carry out its investigation. Such authority is granted to the Office of the Director of Public Prosecutions. This is a case where there is a charge sheet, and the prosecution wishes to have the suspect hearing and take plea. If I comprehend their stance correctly, the investigations have concluded, which is the reason the charge sheets for both cases of both files were drafted and filed. However, the defense counsel has informed the court that he has written to the DPP and that in his letter, part of which he read out to this court, they have raised some issues, including issues which touch on the complaints they have raised before this court. Mr. Bore has acknowledged that indeed the said letter was received, but he needed time, at least a week, to seek directions from the DPP. Under Article 157 of the Constitution, the DPP can direct the Inspector General, and in this case, investigative agency, to investigate any information or allegation of criminal conduct, and the Inspector General shall comply with any such directions. Article 157(6) of the Constitution further lists the powers of the DPP which are listed in or replicated in the ruling. Indeed, it is accurate that Honorable Kore and this court directed that the suspect in this matter be afforded a chance to provide his statement. However, in light of the new information indicating that the relevant statement has already been recorded, it would be inappropriate for this court to require that the statement be recorded prior to the suspect taking plea. Given that the prosecution counsel requested additional time to obtain further directions from the DPP, I'll leave that office to determine whether it is essential for the suspect to provide a further statement, considering that the court has been informed that he has already recorded 2 statements previously. Regardless of the directions provided by the DPP, the question of whether the suspect's statement was indeed recorded, as this court was informed from the bar, will remain a matter for trial. Having said that, hereby I'll set this matter for plea-taking before the duty court on a date that we are going to set shortly. The terms of the suspect's release, as set by Honorable Kore, shall however remain enforced pending taking of the said plea. Those are the orders of the court.
Thank you, Your Honor. We must state from the onset that we are satisfied with that ruling, especially the clarity that the court has brought insofar as the question of recording of the statement is concerned. The reading of the law by the court that this will be a trial issue is accepted, and we consider it as dispositive of that issue. We no longer want to pursue it beyond that level. Secondly, Your Honor, as the court has indicated, and I believe on the aspect of the ruling, we are all united, because I don't think the prosecution counsel is agreed by the ruling. We are also not agreed by the ruling. So as far as the directions on plea-taking are concerned, Your Honor, I just have one more intervention. I pray that the court indulge us on this. The charges belong to the DPP. The conduct of the prosecution is the work of the DPP. Under Article 157, Sub-Article 6, as read together with Sub-Article 10 and 11, the Director of Public Prosecutions has the authority to initiate, continue, and discontinue criminal charges against anyone at any time.
So that I understand what we are submitting.
Yes.
Is it
the question of when the suspect can take plea? I just wanted to submit that we take directions on that, taking into account that it would be better to take a mention date to confirm the status, because we could come back. The upshot is we could come back here on the date appointed by the court, since these charges are under review, and the DPP could say, I have looked at it and I've decided to discontinue. There's a possibility in law. And then it would not, in terms of sequencing, I would appeal to the court that we take a mention date to confirm progress. Then on that mention date, then we can now set a date for plea. Partly because, Your Honor, I'm not trying to be difficult, and one of the things I've advised my client here is that when the court sits where it sits, looking at counsel and the case person and all this other counsel, one of the things that we must not do as defense counsel is to lose favor with the court. Because then, once you lose favor, there's a lot of discretion the bench exercises. So we don't want the court to look at us as undecided, stubborn, or inhibiting of the prosecution counsel's mandate. which includes the power to review the charges and make a decision whether those charges are still tenable. So I would request, with concurrence from the prosecution counsel, that we reserve a mention date to get progress on the request for review. Then on that mention, if that request is declined, then the court can direct plea taking even to happen immediately. I think that balances both ends. As counsel for the accused, we would advise the suspect to come to court in readiness for plea taking, because nothing stops the court on that day to direct plea taking to happen immediately. But for now, we can only take a mention date to confirm the erections from the DPP. That is all we want.
But they fix it for plea, and then there are further developments. I believe the prosecution counsel will inform the court.
Yes, Your Honor,
the court will give orders as appropriate.
We can do that. We hope the Honorable Court has.
And since it's already in my ruling, I'm not about to go by your proposal. So I would rather it went the other way. In terms of taking the date for plea, then whatever happens in between, of course, as between the two, that is a counsel on both sides. I think you'll inform the court about it.
That is still one way to look at it.
Thank you for the ruling, Mr. Mori, for the step. Your Honor, as we submitted yesterday, we appreciate the ruling, and I already indicated yesterday I only need 1 week to.
There was some charge sheets which are, because I did not even mention them, take back the document so that you deal with it that the day that was set.
Your Honor, as my senior stated, I don't forgo the review process just because the plea date was set. Your Honor, we continue with the review, but we wanted to also take a plea taking dates before DT court. If the DPP gives any direction, we will inform the court on that day. Your Honor. That is all, Your Honor.
Nineteenth of December.
Yes, we can move to 19th.
Over 2025.
Just before the final response, just to say that those votes must be extended. No, maybe I may have missed that until that time.
But that is in the body of my ruling.
Oh, okay.
Yes.
Thank you. I don't know if we don't meet again, Merry Christmas.
Merry Christmas to all of you. Just before you walk out,
There is no miscellaneous number 1640 of 2025.
Abala Wanga versus Republic is marked as closed.